The Colorado Court of Appeals is now in session. The Honorable Craig Welling presiding, and the Honorable John A. Robert Hopper. Please be seated.
Thank you very much, and good morning, everyone. The first case that we are going to call this morning is People v. Roderick, 14CA0474. Counsel ready?
Yes, sir.
Okay. And have both sides had an opportunity to review the procedures for this morning's argument?
Yes, sir.
All right. One thing that I am going to remind counsel of is that these arguments are being broadcast on the internet and will also be archived on the court's website. So any sensitive information that you do not want out there, I would ask that you be sensitive to that when you make your arguments. And with respect to this case in particular, as we talk about various witnesses who may be relevant to this morning's arguments, if you would refer to them either by initials or job title or something that describes who they are without specifically identifying them, I would appreciate it. With that said, you'll notice when you get to the podium, I've added an additional minute to each of your time. What I'm going to ask you to do is maybe take a minute to just set the stage a little bit for the students. As you know, the members of this court have read your detailed briefs and are familiar with the facts, and the students have been familiarized with them to some extent, but that might just be helpful to orienting everybody, and I'll give both of you a minute to set the stage in that manner. With that, are we ready to proceed? Very good. For the appellant. Very good. You may begin. Can everybody hear her? All right, let's do a mic. Where's the microphone on your? Is there a microphone on the?
Testing. It's taped up.
Is it?
Side, and you have to I will do my best. Is this any better? Yes.
All right.
So here today we have a case. This is a self-defense case where two coworkers got into a fist fight early in the morning at their job site. Both people said that the other was the initial aggressor. And what happened in this case was my client was charged with assault and also menacing. The jury hung on the assault count, but ultimately convicted on the menacing count. And sort of what happened with the menacing was after there was a scuffle, my client testified that the alleged victim was on the ground. He wasn't sure if he was going to come back at him and re-engage, so he bumped into a fire extinguisher. He picked up the fire extinguisher just to sort of have something in between himself and the alleged victim as he came at him. And so that's the basis for the menacing with a deadly weapon.
Wasn't there conflicting evidence on that, counsel, indicating that there might have been a separation between the assault and the menacing event?
Yes, Your Honor. One witness testified that my client had gone outside and come back in, picked up the fire extinguisher, tapped the alleged victim on the shoulder, and said, would you like some more, or something to that effect. So that's the conflicting evidence there.
That was the mechanic? I
yes,
forget his name, the mechanic. But doesn't the record indicate that as the mechanic was helping Mr. Churchill clean up over the sink, that's when your client approached with the fire extinguisher and asked, have you had enough, or do you want more, or something like that?
Yes, Your Honor, that was the mechanic's testimony.
And wasn't that testimony also corroborated by I think it was the parts manager or service manager who said he entered about the same time that he heard that conversation going on between the mechanic and Mr. Roderick?
My memory of the record, Your Honor, is that two of the other coworkers did come in, and one remembered my client saying, would you like some more, and the other did not remember that. That's my memory of the testimony, Your Honor.
Okay.
If I may jump into the first issue.
Please do.
So in Colorado, general arguments that a defendant is tailoring his testimony simply because he was present at trial is prohibited. And in the words of Justice Ginsburg, that's because doing so transforms the defendant's presence at trial from a Sixth Amendment right into an automatic burden on credibility. And it violates the general rule that you shouldn't comment on a defendant's exercise of his constitutional rights. And here, the constitutional rights, you have the constitutional right to attend trial, to confront witnesses, to testify, you have the right to notice of charges, and you have the right to participate in your defense. So in this case, in rebuttal closing, when the prosecutor said, Mr. Rodriguez had the luxury of sitting here, and so he's had the luxury of hearing what everyone else has to say. That's the kind of general statement, not timed to anything specific, that the Colorado Supreme Court has said is not allowed.
Didn't the potential tailoring problem here actually begin long before rebuttal close and began with some questioning of Mr. Roderick, as well as some other argument?
Yes, Your Honor. So one of the first questions, or if not the first question in cross-examination, was the prosecutor asked my client something to the effect of, you had referenced reading the witness statements on your trial on direct. And that testimony was something about, well, I couldn't remember when another witness had gotten there. He usually gets there at 6, but I remember seeing in his statement that he said he was at 7 on that day. So it wasn't really a contested fact. I did just mention that, I remembered in his statement he had said something different. So on cross-examination, the prosecutor followed up with that and said, so you read his statement, didn't you? And in fact, you read all the witness statements, didn't you? To which my client said that he had. And my argument is that commenting on your right to look at the evidence against you before trial is just as improper as commenting on your right to attend trial.
Was there any objection either to the testimony or to the arguments of counsel?
No, Your Honor. I do believe that this error is plain, but there was no contemporaneous objection.
Isn't plain error a pretty heavy burden to shoulder? And how would you shoulder it in this case?
So there's two parts to plain error. The first is obviousness, and the next is whether it's substantial. As to obviousness, the Martinez case from the Colorado Supreme Court had come down, I believe it was 3 years prior to the trial in this case. So that had been the law in Colorado for some time. The judge should have known that and should have been able to cure that problem without benefit of objection. And the general rule that you shouldn't comment on a defendant's exercise of the constitutional rights, that's been a long-standing rule. The cases I cite in my brief go back to the 60s. I believe it's potentially even prior.
But here the line's not so bright because there's proper tailoring, a proper tailoring argument and improper tailoring argument. And one is when it's based on a specific inconsistency or the door has been opened to it versus just a generic tailoring argument. So just because there's questions about that doesn't necessarily alert the judge in the same way that a comment on the defendant's silence or failure to testify or exercise of other constitutional rights may trigger a trial court judge to intervene without the aid of a contemporaneous objection. Isn't that the case?
That's certainly true that there is specific tailoring arguments can be made. I would point out that the prosecutor's questions here are almost identical to the ones that were held in Proper and Martinez. And also just looking at the words that the prosecutor used should have put the court on notice of that, saying, it was his luxury to sit here and attend trial. And also the fact that that statement was made and while the prosecutor said, the defendant, of course, is biased in working around the facts, and we're going to go through that. But then the prosecutor, in fact, never did go through that. Just gave a general summary of what Mr. Rodriguez had testified to, but never pointed to anything in the record to indicate that he had changed his testimony after listening to any of the witnesses testify or after looking at discovery, for that matter.
And Mr. Roderick hadn't given any statements to, had Mr. Roderick given any statements to police?
He did, Your Honor.
So, I mean, this is that's the very sort of circumstance where a tailoring argument may arise, is that now that we're at trial, you've changed your story that you gave to police. And that's a specific tailoring argument that would be permissible, right?
Yes, Your Honor. So if they had given one account to the police after listening to witnesses, there was something different, and then at trial they had testified to sort of conform to what the witnesses had said, that would be a specific tailoring argument.
But no such instance of that was raised on cross-examination or from any other witness, is that right?
No, and in fact, Mr. Roderick's testimony was consistent the entire time. The statement he gave to police was not, it was in great detail, but it then claimed self-defense from the beginning, saying that the alleged victim had sworn first.
Counsel, how was he prejudiced in this case? Remember, it's got to be even a type of a serious type of prejudice to qualify as plain error.
Yes, Your Honor. And so this is an attack on my client's credibility in a case where credibility is absolutely key. This is a self-defense case where my client testified. He is the only witness really testifying to those version of events, so his credibility is of the utmost importance. And an attack on that could be extremely harmful. And also just the use of the word luxury, it implies that this is my client's constitutional right and his statutory obligation to be present. It's not a luxury for him to be there.
Is it a per se rule you're arguing for? If it's an adverse comment on a credibility, it's per se reversible error under the plain error rule?
No, Your Honor, I'm not saying that. I'm saying that it still needs to meet that the burden that it was substantial, and I'm arguing that here it was. Because of the facts of this case, that it's a self-defense case where my client's credibility is so crucial. And I think...
And they believed, or at least believed him enough to find, for some of the jurors, reasonable doubt on the question of self-defense, insofar as they hung on the self-defense count. So how does the fact that they hung on one of the counts but convicted on another play into our analysis of the prejudice prong, or the impairment of substantial right?
Right, so this was a close case. The jury thought it was a close case. And had it not been for this improper attack on my client's credibility, they might have acquitted or hung on the menacing count as well. So I think particularly in these facts where my client's account of his self-defense was fairly convincing. I mean, the alleged victim was a Golden Gloves boxer, and he was bigger than my client. He bragged about getting drunk and getting into fights. And so all that taken together, I convinced at least some members of the jury that he probably swung first. And had there not been that improper attack on his credibility, they might have also believed that when he picked up that fire extinguisher, he did that as a further act of self-defense and not as medicine.
Do you want to turn your attention to the evidentiary issue at all?
Yes, sir. I can move there now if there's no further questions on the first issue. So the second issue, again, this is a self-defense case. Two workers got into a fight first thing in the morning, and they're both saying the other is the initial aggressor. Now, one of those people there's testimony that there would have been testimony that he came to work intoxicated more often than not, and that evidence was kept from the jury.
And you contend it should have come in as habit, correct?
Yes, sir.
Is habit more often than not, or is it something more than that? Do you have a more often than not example of qualifying as habit or routine practice?
So I don't, Your Honor, and looking at the cases, it depends on what the habit is for the courts to determine whether it's enough to cross that line into habit or not. I would say in this instance, going to work drunk more often than not is enough to bump into that line as being a habit. And so sort of the thing that I had thought of, for me, first thing I do in the morning, more often than not, is I make coffee. And so I think that would be proper evidence to say that it's my habit to make coffee in the morning because I do it more often than not.
Counsel, let me ask you, you said more often than not may be based on context. Do you have any cases that you cited in your brief about habit being based on more often than not?
I don't believe I have any cases saying that specifically, Your Honor.
And I guess sorry, Justin. No.
I was just going to ask you, the cases cited by the opponent, do they stand for habit means always?
Not that I recall. I can't recall off the top of my head.
I'll ask them.
And I guess I think of habit more along the lines of, I don't know if I did something on a particular occasion, but because it's become so routinized, I did. In other words, I can testify that I ate a ham sandwich on a particular date because it's Tuesday, and I always eat a ham sandwich on Tuesday, and it's my habit. Therefore, even though I don't have a specific memory of it, because it's become so routinized, you can offer that testimony without necessarily a specific memory, as opposed to just, I have a bad character. I occasionally, or even more often than not, come to work intoxicated, and that to me seems like character as opposed to habit.
Right, and that's what the trial court decided in keeping out the evidence. So I think, and you bring up this difference sort of between habit being a behavior that you can testify to, sort of empirical sort of data that you can observe and testify to, versus character kind of gets into opinion, you know, this guy's a jerk, that's a character. I do think that coming to work drunk is more of a behavior. This is something that witnesses can see. They can say, well, I smelled it on his breath, I noticed his behavior, rather than a general sort of assessment of his character. So I do think that this falls more into the observation of behavior rather than an opinion on his character.
And if the trial court did improperly exclude this habit evidence, as you call it, how was your client prejudiced by that ruling?
So again, this is a self-defense case where the credibility is extremely important, and also in self-defense cases, looking at all the circumstances takes higher importance as well. It would have gone right to the reasonableness of my client's belief that he needed to act in self-defense and to the reasonableness of the force that he ultimately used. It would have corroborated his testimony that the alleged victim was drunk. Again, very important to allow corroborating evidence when a defendant testifies. And it also goes to the alleged victims. It would have supported why, his ability to remember and perceive that day, and it could have helped explain why he couldn't remember much of what had happened. And again, as brought up in the first issue, this was a close case where the jury hung on the first count. Had this evidence come in, had the jury know that one of these two men who got in a fight came to work drunk more often than not, could have gone a long way in helping them come to their decision with my client.
Because he's drunk doesn't necessarily mean he started the fight.
That's something that the jury should have been able to consider when they were determining their verdict.
You think a person being drunk is relevant to having started the fight?
I do, Your Honor.
How about breaking that down for me?
Okay, so sort of when you're drunk, if you're not making good decisions, some people get aggressive when they're drunk, and going straight to the menacing count could have helped explain why even after he had sustained some injuries to his face, maybe he wasn't feeling that, and wasn't making rational decisions about continuing that fight, which could explain why my client was still afraid and felt that he needed to...
I thought that going to the menacing count, he was over the sink. He was standing over the sink. So how does the drunk affect the menacing count?
Right, and so that was one witness's testimony against my client's testimony, which is that was contemporaneous with the fight that just ended. And so again, that should have been a question for the jury to decide whose account was correct, and that could help them in their decision. If there are no further questions, I'd like to save my remaining time for rebuttal.
Very good. Thank you very much, Ms. Pitts. Ms. Adams, I'm going to go ahead and extend you the same courtesy of a minute to kind of roadmap for the students. So,
Thank you, Your Honor.
You may proceed.
Good morning. May it please the court. My name is Rebecca Adams. My registration number is 31044, and I represent the people of the state of Colorado. I think it's important to remember in this case that the defendant was charged with two offenses. He was charged with assault and menacing, but the jury only convicted the defendant of menacing in this case. And that's relevant to both of the issues here and whether or not the defendant can establish that he was prejudiced by any of the error that may have occurred. Now I'll begin by addressing the first issue in this case, which is whether or not the prosecutor's closing argument was improper. Now, while general tailoring is improper, specific tailoring is allowed. And as long as the prosecutor cites to an evidentiary basis in the record, the prosecutor is entitled to make a tailoring argument. Now, in this case, the defendant injected a witness's prior statement into his testimony on direct examination, stating that he had read the witness's statement regarding the time that he had arrived at work, and he implied that the witness had been mistaken in the time that he arrived at work. And by extension, this also attacked the credibility of the victim in this case. In closing argument, the prosecutor
Excuse me a minute. How did that attack the credibility of the victim?
The victim in this case stated that he went and was making a cup of coffee at approximately 7:30 in the morning when he was attacked from behind unprovoked. The defendant said that the victim was not making coffee, that he didn't even remember him with a coffee cup in his hand. But the defendant said that he did recall seeing a full pot of coffee, despite the fact that, for his testimony, no one else was at work yet that morning. So if, in fact, there was coffee, that helps to explain that the victim was getting coffee at the time that he said he was attacked.
How does that attack on his credibility as opposed to saying, well, he very well may have been completely accurate in that? To me, that seems like a concession that the victim's testimony about when he arrived may well have been true.
I'm not sure.
I guess if the defendant is conceding that he saw that pot of coffee, isn't that more of a confirmation of what the victim testified to as opposed to an attack?
The defendant testified that he believed this particular witness, P.S., that he made the coffee. And he said that that was the case because he always arrived at work at 6 o'clock that morning. And when the prosecutor asked if he arrived before him that morning, he said, well, in his statement, I know he said he didn't get to work until later, but I'm pretty sure that he had to be at work earlier that morning because of when he drops his wife off and when he usually arrives at work.
So are you saying that the defendant changed his testimony from what he had told the police earlier to what he's testifying at trial?
Well, he did in fact change his testimony. There was...
So he did not change his testimony?
No, he did.
Okay.
Separate from this discussion, which the
No,
prosecutor...
let's stay with this discussion. This is the one you think is the tailoring argument that's appropriate, so I want to know if he changed his testimony with respect to this.
No, he did. I don't believe he changed his testimony with respect to this. But that's not the only way that there can be a tailoring argument. In Martinez, they talk about whether or not the tailoring can come from implying that a witness is lying. That can be part of the tailoring argument, and that's what happened in this particular case.
Is there an implication the witness was lying or mistaken? There's a difference.
There is a difference, but I think that that's exactly why this is an arguable point here, because there was no objection to this, and he basically said that he believed that this other witness had been to work earlier than he said that he was, and he had argued that the victim certainly was lying when he said that he was getting a cup of coffee when he was attacked, because he said that's absolutely not what happened and that the victim in fact had attacked him. Now, in closing argument, the prosecution specifically referenced this point of the testimony, saying that the defendant mentioned he looked at P.S.'s statement before this trial. Now, because closing arguments are unscripted, we don't require prosecutors to use some rigid formula in making their argument. As long as there is some reference to the evidence of tailoring, the prosecutor's argument is proper.
But that's not a reference to the evidence of tailoring. That's evidence of looking at a statement. That's exactly the sort of inappropriate comment of just the ability to participate in the defense.
Well, I think that the prosecutor might have been slightly inartful in not tying it completely together regarding the evidence. I think that it was clear to the jury what the prosecutor was referencing here. And we have to remember that in this case there was no objection, so we have to analyze this under a plain error standard of review. And in that case, the defendant has to establish that this error was both obvious and substantial, and that this error so undermined the fundamental fairness of the trial that it casts serious doubt on the reliability of the judgment of conviction. And we simply don't have that here. The error wasn't obvious. While there certainly is case law saying that general tailoring is not allowed, it wasn't that clear-cut in this case that that's what this was. And there wasn't an objection to put the court on notice. Additionally, the defendant was only convicted of the menacing count. The tailoring argument really went more toward the assault, because in the assault case, there weren't any independent witnesses of the assault.
Counsel, he wasn't acquitted of assault, though.
He was not acquitted.
It'd be different. It would be different if he were acquitted, but he wasn't acquitted. There were some jurors who thought he was guilty of the assault and may have been influenced in that, and perhaps influenced with respect to menacing by if the argument was improper, an improper argument.
Well, in making a plain error analysis, we have to look at the strength of the evidence. And I think certainly the strength of the evidence is much stronger in the menacing count than it was in the assault count, because we did have independent witnesses. We had an independent witness who witnessed the defendant leave the room, come back, pick up a fire extinguisher, touch the victim on the back, and say, "This isn't over, you want some more of this."
Was there any corroboration of that witness's testimony?
There was another, after the defendant said that, this particular witness had told him, "This is over, put it down." There was another witness who did hear that portion of the conversation where PS told the defendant to put the fire extinguisher down, but there was no one else that heard the comment the defendant made about, "This isn't over, do you want some more?"
So we really have three witnesses that testified regarding whether or not the menacing statement was made, two independent witnesses which were in conflict, and the defendant. So this really does come down to a credibility fight.
Well, the two independent witnesses were not in conflict. It's just that the second witness came into the room after the fact and only heard that portion of the statement. So it wasn't conflicting as if one said it happened and one said it didn't. It was just that one was present for the entire period and one was not.
But there was conflicting evidence between the defendant's testimony and the other witness. And
Yes.
so do you, in doing a plain error analysis, do you just pretend the defendant didn't present conflicting evidence?
No, but I think there are multiple factors that the court has to consider. One of them is the strength of the evidence, and you can, of course, look at both the defendant's testimony and the conflicting testimony. You can also look at the prosecutor's argument in this case regarding the tailoring that went more toward the assault count. There was no argument that there was any tailoring made with respect to the menacing count. And again, we have to look at the fact that this was a minor comment in an otherwise proper closing argument. And prosecutorial misconduct in closing argument rarely constitutes plain error requiring reversal. I think it's also relevant to look at whether or not there were specific instances of tailoring that the prosecutor could have commented on but didn't in making this plain error analysis. This is something that the Supreme Court looked at in Martinez in determining that the error in that case was harmless. And in this case, the defendant did make a statement to the court prior to trial and did change his testimony at trial. So again, while that wasn't something that the prosecutor specifically commented on, that is something that this court can look at in making a plain error analysis.
What is that specific change?
The defendant's statement to the police was that the victim swung at him, he blocked it, and then he punched him in the face. At trial, he testified that the victim came up to him, told him, "You're out of here," and shoved him in the face. In the one instance, he blocked it. In the other instance, the victim actually assaulted him. If the court has no further questions on the first issue, I'm happy to address the second evidentiary issue.
Certainly.
Now, in this case, the defendant wanted to bring in evidence that the victim was drunk at work, or sick at work, or hungover at work, and that these things happened routinely. In order for something to be a habit, it has to be a regular response to a repeated situation. There has to be this regular practice of responding to a particular situation with a particular type of conduct. But it also has to be relevant. And in this case, the defense attorney was very clear in the trial court that there was no history of violence or aggression between the victim and the defendant. There was no history of violence and aggression on the part of the victim based on his consumption of alcohol. And because of that, the defendant had no reason to believe that he was in danger. And in fact, the defendant didn't even testify that he believed that the victim was drunk on the day of this incident. The only testimony that he gave was that he believed that the victim smelled of whiskey. But he didn't say that he was drunk.
Aren't we cutting hairs a little fine here? You don't think he could have argued to the jury that a fellow showing up smelling of whiskey may have been drunk?
He could have, but he didn't. And in this particular case, there was often comments that the victim, when they were talking about trying to get this evidence in, it wasn't always that he was drunk. Sometimes he was just hungover. Sometimes he was just sick. But again, all of this evidence, none of it went to the real issue here, which is whether or not the defendant responded appropriately in believing that he was about to be attacked and therefore responded appropriately and acted in self-defense. There was no evidence here at all that this particular victim ever responded aggressively based on the fact that he may or may not have been drinking.
Could evidence that he had been drinking have supported the theory that the victim was the initial aggressor?
Not without more, Your Honor.
Tell me.
Well, I think in this particular case, and the trial court even it made similar statements when addressing this issue, and the trial court did go over this issue multiple times throughout the trial, talking about whether or not there was any relevancy here. And the court had said if we had some indication that this particular victim was often aggressive or violent when he was drunk, that might be relevant to whether or not he was the initial aggressor here. But the only thing that we have is that he may have come to work drunk on occasion and that he had problems with his job performance as a result. That has nothing to do with whether or not the defendant responded in self-defense, and certainly not with respect to the menacing count.
What about, what about the fact that the defendant may have known about his propensity for showing up intoxicated? Isn't that part of the totality of the circumstances from a subjective standpoint that may help explain how he reacted or give the jury more information about whether his reaction was reasonable based upon his knowledge?
But again, Your Honor, even if the defendant knew that the victim came to work drunk, there was still no reason for the defendant to believe that this victim was violent or aggressive or that he had any reason to be fearful. There had never been any type of altercation at the workplace that involved any type of physical violence with this particular victim.
Couldn't he have argued that a reasonable response may be impacted by whether or not the person on the other side of the altercation is or is not intoxicated?
And the trial court did allow the defendant to argue that on this particular day, the victim, he was able to argue that the victim, he could have argued that he was drunk or that he smelled of alcohol or that he believed that the victim was drunk and that's why he was responding the way that he was. He was able to make all of those arguments regarding this specific instance on this specific day. But bringing in past instances of the defendant coming to work drunk does nothing to add to this particular instance about whether or not the defendant responded appropriately. There was simply nothing to link that to this particular case.
And so defendant did not comment about the victim being drunk or intoxicated on this particular day during this event?
He did not, Your Honor. The only statement that he made during his testimony that he smelled was that he smelled whiskey on the victim's breath.
Ms. Pitts makes the argument that this case hinges on the credibility of the defendant. Do you see any difference in the credibility issue between the self-defense argument, between the assault event and the menacing event which occurred? It seems to me from the record, menacing and assault were somewhat separated. Is that right? Because the defendant started taking his tools outside and loading up things. The victim was over the sink cleaning up when the mechanic came in to help him.
Yes.
What difference does that make, if any, on our analysis?
Well, again, I think going back to the tailoring argument and the evidence that was presented there, that really all went to the assault count, which he was not convicted of. There was no argument about the tailoring which could negatively impact his credibility with respect to the menacing count. And the defendant even admitted that he had picked up the fire extinguisher. No one asked him whether or not he said the words that were attributed to him by the other witness, but he did at least indicate that he had been going back and forth, that he did come back in and he did pick up the fire extinguisher. And then we had an independent witness who stated that the defendant said certain things to the victim at that time. But really, the evidence that's being complained of here really went more toward attacking his credibility, if that's what it could be called, with respect to the assault count.
And how do we know that?
I see my time is up. Would you like me to?
You can go ahead and answer this question.
Again, I think the reason that we know that is because with respect to the assault conviction, we don't have any independent witnesses. We only have the defendant and the victim's testimony, and the victim didn't remember very much, and the jury couldn't reach a verdict on that particular case, which shows that, at least with respect to some of the jurors, that they did not view his credibility in a negative manner and did in fact believe him with respect to that count. The menacing count occurred later. There were independent witnesses. It was a completely separate event, and there was no argument that the defendant tailored any of his testimony.
Very good.
Do you ask one more question? The tailoring comment, wasn't that directed towards the independent witness or tailoring around the independent witness's testimony?
Yeah, PS was the same. No, PS was the one that he commented on in his tailoring. The witness, it was LVH, was the witness who testified regarding the defendant's statements to the victim for the menacing count.
And who had seen him approach with the
Fire extinguisher, yes, that was LVH. PS was the other witness.
But PS was sort of the corroborating witness to that, or potentially corroborating witness.
Well, what all PS heard was that LVH told the defendant to put down the fire extinguisher, which the defendant admitted he was holding.
Or put down something. I think it was, he
Put it
said,
down.
he said, I think it was a fire extinguisher.
Right.
I don't know.
Yes, but the defendant did admit that he was holding the fire extinguisher.
Very good. Thank you very much, Ms. Adams. Ms. Pitts, since we went over a little bit, I'm going to add an additional minute and a half to your time in addition to the time that you had reserved.
So just a few quick points. I do want to mention the inconsistent statement from his statement to law enforcement at the time versus what he said at trial. His statement at the time was the alleged victim swung on me. And at trial he testified, well, he kind of came up to me and shoved my head back and got in my face. He was cross-examined on that inconsistent statement and sort of explained, well, I sort of meant it as one and the same. But I just wanted to point out that he was properly cross-examined where there was that inconsistent statement. I did want to mention that in Martinez, when there are inconsistencies that potentially could be tailored, I don't actually think this is tailored because there wasn't he wasn't changing his testimony based on the alleged victim's testimony, for instance.
But didn't the Martinez analysis go down that road on a plain error analysis to say, well, even though this was improper generic tailoring, because there was evidence in the record that could have supported a tailoring argument, that goes into the plain error analysis?
Yes, Your Honor. That when the prosecutor does not actually specify what the tailoring was, then that doesn't go to the error, that just goes to the harm. And then for the second issue, I just wanted to clarify that the offer of proof was that there were 4 witnesses who were going to testify that the alleged victim showed up to work intoxicated, and it was one witness that was specifically going to testify that it was more often than not. But I just want to...
And wasn't that essentially being offered as classic propensity evidence? In other words, my client has testified that he was intoxicated on this occasion, and now I'm going to bring in a bunch of witnesses that says he does that a lot, and what we want the jury to infer is, on this occasion, he was acting in conformity with his bad character trait. Isn't that classic propensity?
Yes, Your Honor, that's what the Rule of Evidence 406 does. It says that when there's a habit, when there's this observed behavior, that actually is evidence that you conform with that behavior on this particular instance.
As long as the predicate for habit has been established, right?
Exactly.
Which is where the swords cross. Okay.
If there's no further questions, I would respectfully ask you to reverse Mr. Rodriguez's conviction.
Very good. Thank you, counsel. Court would like to thank both lawyers for their excellent briefing as well as their excellent arguments here this afternoon, and also acknowledge that the fact that you sacrificed to come out here to participate. This program only works when we also have lawyers that are willing to make the trip out here. And I know both of you actually work in the building where the Court of Appeals is, so coming out to Longmont is something I want to recognize and thank you both for, and your excellent arguments this morning. With that, the case will be submitted, and an opinion will enter or issue in due course. With that said, we're going to go ahead and take a brief recess. I think you'll have an opportunity to talk to some of the students while we're deliberating the case, and then we'll be back in a little while to hear our second case. With that, Division 2 will be in recess.
All rise.